Hearing in the appeal, Hastings Borough Councillor and not Manolete PLC.
May it please you, my lady and my lords, I appear on behalf of the appellant, together with my learned friend Mr. Jack Parker, and my learned friend Mr. Martin Bowdry, Queen's Counsel, appears for the respondent.
Yes, well, we have discussed the case, obviously, and we do think it's quite a short point. And it did occur to us that the time estimate for your oral submissions was more than generous. So I'm rather hoping that you can, we were hoping that we would be able to complete the oral submissions within the morning.
Yes. Well, it has been agreed at the bar that I should have the longer time.
Well, usually the appellant has the longer time.
Yes.
Having the harder task.
If I could start by saying then that the respondent, Manolete, is, of course, as the court knows, the signee of Styleless Sports Limited, in whose shoes it stands. And this appeal concerns a matter of statutory interpretation, as your ladyship says, a relatively short point, concerning the meaning of the words in default in section 106 of the Building Act 1984. Members of the court will, I anticipate, have read section 106 for themselves, possibly more than once in advance of the hearing. But at the start of it, since the case is all about section 106, I just read it out. A local authority shall make...
Where do we find it on the electronic bundle, please?
My lady, it's MS page 909.
Yes.
A local authority shall make full compensation to a person who has sustained damage by reason of the exercise by the authority in relation to a matter as to which he has not himself been in default of any of their powers under this Act. As it's a matter of statutory interpretation, it's not necessary perhaps to go into the facts in detail at this stage, and I know you will have read the written cases, as you've indicated. However, I do just want to draw your attention to one point in relation to them. The respondent's premises, a bingo hall and an amusement arcade, were at the front end of Hastings Pier, or the relevant section of Hastings Pier, directly accessible from the front, as referred to in the Statement of Facts and Issues. And if I could take the court very briefly to the plan that is appended to the Statement of Facts and Issues at MS 61, I can perhaps show the court where the premises were exactly. The bingo hall is the area shown edged red, or which should be completely edged red, marked C2 towards the top. The amusement arcade is edged blue towards the bottom, marked C15. To the right of these premises is what's been called the pier apron, which was a section of the pier which was not significantly closed by any act of the council or the court order. The respondent's premises had entrances directly out onto the front, as is marked by the doors on the plan, and the barrier was put across those doors by the council, as well as across the common entrance to other parts of the pier. The barriers didn't just go across the central walkway and around the premises, they blocked off the access directly to the respondent's premises. What the respondent's entitlement to compensation is based on in this case is damage caused by the council preventing access by the public to those premises. That's to say, the parts of the pier occupied by the respondent.
If we're looking at the nature of a premises, might it be more important to look and concentrate on what was the extent of the demised premises under the schedule to each lease?
Well, my lord, there's no dispute that the structure underlying the premises was subject to repairing obligations by the landlord, but the area of the premises is shown there, and there is direct access. And what the respondent says is that it suffered damage caused by the closing off of access to that part of the pier.
Yes, but the plan doesn't show the height and depth of what was demised. I think we glean from the schedule to the leases, don't we, that the demised premises excluded the main structural parts of the premises, all the building, and are confined to the premises, in ordinary language, on top of the pier.
Yes, I'm not using the plan for that purpose, but my lord is quite right about that, I'm sure. But I'm demonstrating the point at the moment, just making it clear from the outset, that as the declaration of the High Court itself records at MS 163, the claim for compensation is based on blocking off access to those two sets of premises. And the declaration is that the defendant's liable to the claimant to make full compensation under Section 106 for any damage sustained by the reason of the exercise by the defendant of its powers under Section 78 of the Building Act in preventing all public access to Stylus Sports Limited's premises on Hastings Pier between 16th of June 2006 and 12th of September 2006, when the court order was finally made. And I draw this to the court's attention because it is the entry of the public into those premises which the council took action to prevent, which must be focused on insofar as the facts become relevant, although I accept, of course, that the landlord had the responsibility for the underlying structure on which those premises stood.
Is there a formulated claim for compensation? I mean, I've seen sort of figures of 4 million bandied around, but has there actually been a formulated claim?
There has in the arbitration, yes. What the respondent said...
Not in the papers?
It's not in your lordship's papers, but what the respondent says is that although it had businesses throughout the southeast of England, because these premises were closed for 3 months, the whole business, the whole group went into liquidation ultimately, and that should be the subject of the statutory compensation.
Obviously that's going to be an issue.
Yeah, well, it most certainly is going to be an issue. It's not acceptable.
But not one that we need to get too concerned about.
No. But my lord, that is the situation factually. And in the courts below, there was no dispute that in default meant in breach of obligations, but the court added the words under this act, and the Court of Appeal, following the decision of Mr. Justice Ramsey, considered that on the basis of the respondent's argument, the words in default should be read as in default of obligations under this act. And the submission of the appellants is that that is simply wrong.
They said that even if you were wrong on that, in fact, you wouldn't get home anyways.
Well, my lord, they made comments in passing.
We'll come to that.
And I submit they were only comments in passing because they didn't analyse the facts or the evidence, because they focused on the point of statutory interpretation, as this court does. And
usually we should just take in default as it stands and ask what in common sense it means and whether it applies in this case.
that is the first, and your lordship might think the best part of my argument.
Well, what's wrong with that?
I don't think there's anything wrong with that, and that's what I'm going to ask you to do. I'm going to add a number of other points, though, which support the same interpretation, although I'm going to take them very shortly, in view of what Manolete just said.
I mean, one of the difficulties about saying it means under this Act is that the acts have changed. I mean, we've seen over 100 years this formula has been used in a whole succession of acts, which have a whole range of different obligations, requirements, and it's pretty odd to think that Parliament was actually intending this innocent little word to encompass all the various different variations of obligations that you've got over the last 100 years.
I can take it shorter than I was going to, because my Lord's made my first point.
I mean, that's just my immediate impression.
We've got to begin by identifying, have we not, the matter in relation to which the local authority has exercised its statutory powers.
My Lord, certainly.
Once you've identified the matter in relation to which they've exercised their statutory powers, you then ask, is the applicant, or was the applicant, in default in relation to that matter?
My Lord, yes, which raises a slightly different question.
And the courts below have said the matter in relation to which the local authority exercised its statutory powers was the defective state of the substructure, and that was not a matter in respect of which the applicant, the respondent, was in default, because it wasn't wasn't within their demise. They weren't liable for any statutory nuisance. Now, which of those two conclusions, those two parts of the reasoning, do you say was wrong? The first or the second, or both?
Well, my Lord, what I say the matter was the admission of the public to the respondent's part of the pier, the part of the pier its units were standing on, which, when they were admitted, were dangerous. and they were dangerous because of the load that was being put on the structure by the public, given the condition it was in. And that loading is crucial, and that the admission of the public was the matter of danger, can be confirmed in more than one way. The first is that the court made its order subsequently under section 77(1)(b) of the Building Act, and that's contained in volume 1 of the authorities bundle, MS page 883. And subsection 1 reads, if it appears to a local authority a building or structure, or part of a building or structure is in such a condition or is used to carry such loads as to be dangerous, the authority may apply to a magistrate's court, and the court may be, where danger arises from overloading of the building or structure, make an order restricting its use until a magistrate's court, being satisfied that any necessary works have been executed, withdraws or modifies the restriction.
What was the relevant structure?
The structure was the pier.
That's the point.
That's the point.
It was the whole pier. If you look at the plan on MS61, you didn't just close off the respondent's premises. You closed off the pier.
Well, my lord, yes, and that's why I was trying to draw to the court's attention the fact that we have a claim here based on specific damage, and the damage it's based on is closing off the respondent's premises. Even if none of the other parts of the pier had been closed off, the respondent's premises were closed off, and the respondent's premises could only have been closed off by the magistrate's court or by the council exercising its power if they were within section 77(1)(b).
But going back, the building or structure in such a state is in such a state or is used to carry loads as to be dangerous, that which creates the danger and therefore triggers the statutory power is the condition of the structure, isn't it?
Well, it's a combination of the two, I would suggest, my lord. If you simply have the pier with nobody being admitted to it, or you have the units with nobody being admitted to them, the exercise of the power wouldn't occur because the exercise of the power is based on the loading, and the person doing the loading is the respondent.
Well, among many others, but if it's in a danger, if its condition is dangerous, don't they have a statutory power to intervene? They don't have to show that somebody is walking along it, do they?
Well, my lord, my submission is that, as far as it comes to the fact, Stylus was responsible in two ways, as my learned friend puts it, for the condition of the pier. First of all, he shouldn't have been admitting people to that part of the pier if they were not safe. And secondly, it had power, as has been accepted by the courts below, and as is the law, to carry out the repairs if the landlord didn't. So if it was going to carry on admitting the public and loading the pier, it could and should have made the public reasonably safe and employees reasonably safe when the public went in by carrying out the repairs itself. But what caused the danger was the admission of the public, and that is the background, although what the appeal is really about, I would suggest, is the question of whether someone who admits people to dangerous premises, more particularly if the power had not needed to be exercised otherwise, is a person who is or is not in default when it comes to be analysed when he makes a claim. At the time when the council acts to close the pier, it's not concerned about who's responsible or who's done this or who's done that. It exercises an immediate power, which can only be exercised under Section 78 in a case of immediate danger. It necessarily would do that before a court order. If it had a court order, it wouldn't need to exercise the Section 78 power. When someone makes a claim, the question for the authority and then for the courts, if there's a dispute, is the person who makes the claim in default?
Who is the person against whom the order under Section 77 was sought?
The person named in the summons was Ravenclaw, the landlord, and again the council acted quickly because it was done the same day as the closure. But Stylus intervened in the proceedings and participated in them. And indeed, there was more than one adjournment, one of which the council says was because of Stylus.
Well, there may be an interested intervener, but the statute provides, doesn't it, 77.1a, where danger arises from condition of the building, make an order requiring the owner, and then B deals with overloading and makes provision for the order for the service of the order. And I was just seeking to clarify at whom the action taken by the local authority was targeted.
Well, my lord, if an order is made under Section 77.1b, it's my submission that anybody who fails to comply with it would be in breach. But the point is...
We're concerned with 77, we're concerned with 78.
Well, we are concerned with Section 78, and Section 77 doesn't give the answer to who's in default because it's exercised before.
I don't think you can be right, because 77.2 says, if the person on whom an order is made under subsection 1a fails to comply with.
Yes, my lord, but that's 1a. It's not 1b.
Yes.
And then what are the provisions?
That distinction, I would suggest, supports my submissions because 1a doesn't restrict it to the owner. 1b doesn't restrict it to the owner. And it's obvious in my submission that it doesn't restrict it because, apart from anything else, very often, almost always, it'll be the occupier who's doing the loading.
But 77.2 is permissive. It provides a gateway for the local authority to do something. And because it doesn't build on 77.1b, that provides no gateway to the exercise of a power under 77.2. But what does that prove?
Well, my lord, I would suggest that it's a little bit of a red herring, although in a sense it supports my case that it relates to the owner only under 1a in terms of not complying with an order. But what 1b does is to focus the fact, bring to the reader's attention, and this court's attention, that the danger arises from the overloading of the building, not the condition per se.
But there are two things. One is, this is with respect, I don't see why this helps us. There are two things. One, someone's got to do the works. The other is that people haven't got to overload it in the meantime.
Yes.
Two is the first part is dealing with who's going to do the works if the person responsible defaults. But obviously that doesn't have any impact on not overloading in the meantime. And so anyone who overloads in the meantime, if that's contrary to the magistrate's order, is in breach.
Yeah.
But it's got nothing to do with 78, which is what we're concerned with, which is the emergency works. It's only under that power that any compensation arises.
Well, Lord, I'd respectfully agree. I see the concern of Lord Toulson, but now it's been explored. I hope the court will be satisfied that that is the position, because Section 78 does relate to what happens in the meantime. That is the whole point. And there can't be anyone in default under Section 77 at that time, because the order hasn't been made under Section 77 anyway.
But 78 is much more general. They have to do whatever's necessary.
Yes.
And they have to serve it on the owner and the occupier. So it obviously impinges on both the owner and the occupier. And then the only question is, well, were they justified in using their emergency powers rather than going to the magistrate's court?
Yes. And with the point I started off on, I said in response to Lord Toulson's question that there were more than one ways of demonstrating the responsibility or the fact that Stylus could have taken action, and that would have prevented all this. And that is that after the order was made, Stylus did in fact repair the...
Yeah, but where wasn't what led to your emergency action? What you were worried about was these two big events in the end of the pier. There's no suggestion that what Stylus was doing was actually dangerous. It's none until you served your order.
Well, that is really the point, that the local authority doesn't look at who's responsible, and the courts don't. And even now, what you've got to look at is who's in default, but they don't look at that until someone makes a claim for compensation. Now, when someone makes a claim for compensation, the question is a legal one, which is, What do the words in default mean? And is the applicant for compensation within the meaning of the word in default or not? Is it entitled to statutory compensation? Could Parliament have intended a person allowing people into dangerous premises, if they are in breach of their legal obligations in doing that, should have compensation or not? And it's in that way...
I mean, that argument I don't understand, because Section 78(7) clearly anticipates that even if you're in default, you can still get compensation if the authority wasn't justified in using their emergency powers.
Yes,
So there's no sort of general principle that people who are in default are sort of somehow banned. On the contrary, the key question is, were you justified in using your emergency powers rather than waiting for the magistrate's court?
Yes, and no one has suggested here, in this case, it's not been alleged.
No, you clearly were entitled to do what you did. Obviously, you'd have been negligent if you didn't. But the question is whether the default impinges on that particular exercise of your powers.
Yes, and could I give the court some examples of what it would mean if the interpretation of the courts below is right, that this is confined to breach of obligations under the Act? If an office building was hit by an aircraft in the City of London, and if people were admitted to the building, they would be in danger. You can see...
I don't think you need to... We've seen those in your papers, but I don't think they really help very much, do they?
Well, my lord, in my submission, it would be, with respect, scandalous if, and it cannot have been the intention of Parliament, that if some building was hit by an aircraft and it was dangerous to let people in, the person doing the letting in, which is what really gives rise to the danger, even though they've got no obligation to repair, even though the incident isn't due to their conduct, is entitled to statutory compensation when they're prevented from doing the very thing which is necessary to remove the danger.
Mr. Gatsby, forgive me constantly interrupting. May I have asked one further question prompted by what you just said? Does it follow from your argument that the occupier can never be entitled to compensation under Section 106?
No, because there could be circumstances in which an occupier was not in default. There could be, to maintain my present example, if a building is leaning dangerously because it's been hit by an aircraft, the building next door could be closed off, and the occupier of that building would not be in default in any way. Or someone who had a right to go into the building who wasn't an occupier could be entitled to some form of compensation. But even if it did mean that, it wouldn't prevent someone from being entitled to compensation. And why should it? Because if they are in default and if they are letting people into a dangerous building in breach of obligations, why should they have compensation?
As I see what you say, subsection, it refers to the occupier of any premises. It doesn't have to be the occupier of the relevant premises who may have suffered damage.
Well, that's the same, my lord, and in a lot of the historic cases,
Yes, I follow that point.
the court may have seen other premises are closed off to deal with a problem on the roads or some sort. So, my lords, I'll whisk through the legal arguments that I say apply, the first of which has been mentioned by Lord Carnworth. I could perhaps sit down at this point, but I'm not going to be that confident, so I'm going to bolster my submissions, unless I'm told otherwise.
Don't take anything I say as necessarily representing the views of the court.
Absolutely not. But there is, first of all, the plain meaning of the words, and I would respectfully refer just to the quotation, one passage from Lord Reid that's mentioned in Bennion on Statutory Interpretation, which is in Authorities Bundle 3, tab 11, MS page 1565. And my lady, my lords, it's the paragraph towards the foot of page 508. The plain meaning rule was expressed by Lord Reid as follows. In determining the meaning of any word or phrase in a statute, the first question is to ask always, what is the natural and ordinary meaning of that word or phrase in its context in the statute? It's only when that meaning leads to some result which cannot reasonably be supposed to have been the intention of the legislature that is proper to look for some other possible meaning of the word or phrase. And my submission is there is nothing restricting the ordinary use of the words here, so that they shouldn't cover breach of any obligation, mainly covering, as the Court of Appeal held, breaches of obligations under the Act itself. However, even if there was any doubt in the matter, one would have to look to common sense. And so far as that goes, I've dealt with the matter in paragraphs 32 to 34 of our written case.
Well, speaking for myself, I think common sense is a very dangerous concept.
Well, some have said that sense isn't always common.
It means different things to different people.
Yes.
In other words, there's nothing common about common sense.
No. But here I would hope that everyone would agree that, and the public, I would suggest, would expect that statutory compensation is not to be paid to people who are allowing people to go into premises if they are in breach of their obligations in doing that, which means the council has to take action to stop them doing it.
And that's the mischief with which you're concerned, but you're assuming that the only way to deal with that mischief is to interpret the statutory wording of 1061 broadly. If there was an entitlement to compensation, but the only way that the profits claimed as compensation could be earned would be in breach of a statutory duty such as occupier's liability or a breach of the Health and Safety Act, would you not have a defence in the claim for compensation on the basis that the money could only be earned illegally?
Well, my lord, I can tell you that point is not one which has been lost on us, that the occupier would not be able to earn any profits because he would then be in breach of the Act and so on. The response that is given is that the Act does not require anything other than default to be inquired into, and the Court of Appeals said it was not for the arbitrator to inquire any more than the court into the question of whether someone was in breach of other obligations, in addition to which breach of the Occupier's Liability Act, it would be said, is not illegal. It simply is a duty you are under to not admit people to dangerous premises. And your lordship may remember that in the Court of Appeal, the second point was taken, that what was happening here was in breach of the law, and that any profits earned from that should be prevented by the court from being recoverable by the interpretation effectively of Section 106 as not entitling the person to bring a claim for compensation in those circumstances, and that was rejected by the Court of Appeal. I would suggest that that second route may be open to the respondent, the appellant, and I suggest that it would apply, and it would obviously apply. But we're at the stage first of whether the appellant is in default. And if he is in default, why should he have an entitlement to compensation in the first place? Because the Act says he should only be entitled to compensation if he is not in default, in breach of his legal obligations, in relation to the matter, in relation to which the Council exercises its statutory power. I submit that the court ought to say it's not appropriate, and that the reason there may be no cases on Section 106 in this context may well be that no one has thought previously that it would be contemplated by the courts that someone in breach of their own obligations should receive, in principle at least, a right to compensation given by Parliament for being prevented from continuing in breach of those obligations by the exercise of the statutory power.
In default is a curious expression to use, is it not? Because if your argument is right, because in default immediately invites the question, in default of what? And your argument is in default of anything, really.
Well, I wouldn't go as far, I don't need to go as far as a moral duty. I go as far only as a legal duty identified by the Council as being one the party is in breach of. It comes from the Victorian age. It does still mean, as the Oxford English Dictionary shows, in breach of obligations or requirements. And I agree that you wouldn't normally say a person is in default of his obligations under the Occupier's Liability Act, but one wouldn't normally say a person is in default of his obligations under the Building Act. You normally say he's in breach of his obligations. But default is a wide enough word to cover all forms of breaches of obligation. And in saying in default...
Why not use the word in breach of legal obligation?
Because that's what default means in my submission. But the one thing it can't mean is in breach of legal obligations under this Act, because then you need to add some words in whether you use default or breach of obligations.
Well, you need to add some words in on your formulation as well, don't you?
Well, not if
In
default...
default of legal obligation.
Well, not if that's what default really means, which is what I submit it does. And this leads on to my next point. There has to be some purpose in my submission behind the caveat, the end of section 106. There has to be some purpose to that caveat. A person in default does not receive compensation. The court may want to think about what that purpose is, because I submit that the caveat to section 106 is not there as some sort of academic exercise which catches the applicant out if he's in breach of an obligation under the Building Act, but which leaves him free to claim compensation, whatever breaches of other acts or duties at law arise. And the purpose of it is that it's to disentitle you to compensation if you are a person who is being stopped from doing that which you're obliged not to do anyway. Or in the context of another case, made to do something which you should have been doing anyway. So if, in breach of their legal obligations, someone admits the public to a building that will be dangerous if they're admitted, and the statutory powers exercised to prevent the public from going in, they shouldn't be entitled to compensation for something they shouldn't have been doing anyway, as it was in breach of their legal obligations. The more particularly if the statutory power wouldn't have needed to be exercised otherwise.
More particularly, so I see you're saying it's not confined to the Building Act, but are you saying that the default can extend beyond a default that is causally connected with the exercise by the local authority of its powers?
Well, for the purposes of this case, I wouldn't need to go so far, because my submission is that there plainly is a connection. If the public had not been being admitted, if the loading had not occurred, there would not have been a need to exercise the statutory power. But, since this court is concerned with matters of principle, I would put my submissions wider than that, and I would suggest that the caveat to section 106 would apply whenever, first, but for the breach of the person's legal obligations, howsoever arising, it would have not been necessary to exercise the statutory power.
But it would have been necessary to exercise the statutory power here, would it not, if the amusement arcade and bingo hall had been shut? Looking at the notice which the local authority issued to explain its actions.
It wouldn't in my submission, because if the public were not going in there anyway, there would be...
But the public was using the pier.
Yes.
For matters unrelated to the applicant's activities, wasn't it?
Well, the pier was being used by other people, certainly.
And if one looks at the notice issued by the local authority when it intervened and explained to the public the reasons for its intervention, it would appear that it would have taken exactly the same action even if the amusement arcade at that time had been closed.
Well, again, in my respectful submission, the need is to focus on whether the person was in default at the time.
Yeah, but do you accept that proposition as a fact?
No, I don't accept that the respondents' premises would have had to be closed if the respondents had not been admitting the public to them.
I understand it. The point is that even if the amusement arcade had been closed at the relevant time,
yes,
for whatever reason, you would have taken the same action because you were worried about 500 guests going to a nightclub at the end of the pier.
There would be no need to put the barriers across the respondents' doors if the respondents' doors were closed and locked.
I see. So there would have been a different form of action.
Well, the central walkway would have had to be shut off. And access to other premises would have had to be shut off. but the exercise of the statutory power in relation to the damage for which the claimant claims, the closing off of its premises would not have been necessary. So if it was in breach of its legal obligations in not locking those doors, and the council stopped people going in, its claim for damage is based on that act, not in shutting off the access to the rest of the pier.
Yeah, well, you may at some stage, I think, have to help us about just on that small point of fact. I don't want to take you out of your course, but in Part 5, page 476, and I have no idea what the MS number is, you've got the statement, but I wouldn't want you to intervene in your development of your legal argument.
My Lord, I'll certainly take the court to the facts if I may. The point that I'm dealing with at the moment is the legal point of what Section 106 and the caveat to it relates to, and I've suggested that it would apply first when, but for the breach of the person's legal obligations, however so arising, it would not have been necessary to exercise the statutory power, which is the point just discussed factually. But I'd also suggest, although I don't need to go this far, I submit, that second, where the exercise of the statutory power prevents a person from doing something he should not have been doing in breach of his legal obligations, or where it requires him to do something he was in breach of legal obligations in not having done, that is a second and separate reason why compensation should not be payable and why he is in default in relation to the matter in respect of which the council exercises its power. And the Act doesn't use the word causes, it uses the words he is in default in relation to. And my submission would be that two situations are covered. The first, as I've described, where but for the breach of the obligations it wouldn't have been necessary to exercise the power. And second, as again Parliament surely intended, where the exercise of statutory power, whatever causes you to exercise it, prevents someone from doing something he shouldn't have been doing anyway, he will be in default and not entitled to compensation. And that second part also ties in with the case of City of Manchester against Fram Gerard, which is in Authorities Bundle 3 at tab 14. That's MS 1600. And I'll come back to my Lord's point about the notices issued at the time, of course, shortly. Well, it's a very short point. This was a contractual case, so I accept it's a difference. It's in Authorities Volume 3, tab 11, MS page 1600.
Tab 14.
You said it was 14 last time.
Oh, I'm so sorry, my lady.
It is 14.
It is 14. I do apologise. I think I'm still thinking of Lord Toulson's point about Manolete. I'm so sorry.
Very, very distracting.
So what's the point of this case, which is about something completely different?
Well, it's about the meaning in a contract of the words in default, and it ties in with what I say the meaning on the second limb is of default in the Act. Could I ask the Court just to note the clause concerned at the bottom of page 75, MS 1601? I'm not saying this is a deciding point, it's a contractual case, but could I take the Court next to page 90 of the report, MS page 1616? It's after the quotation given from another case. Below that, Mr. Justice Carr says, it ultimately became common ground that of the words negligence, omission or default, the word default would be the easiest for the plaintiffs to establish. So even though one might think it's an unusual word sometimes to use, it was used here as well. And that is sufficient for present purposes to consider the position on this basis. Adapting the words of Mr. Justice Parker from their context to a context like the present, I think the default will be established if one of the persons covered by the clause either did not do what he ought to have done, or did what he ought not to have done in all the circumstances, provided, of course, that the remaining provisions of the clause were also satisfied, and that the conduct in question involves something in the nature of a breach of duty, so as to properly be describable as a default. My lords, that forms the basis of my second, though I say...
But I mean, one's got to read that in the context that the clause requires the default to cause a particular loss. That's clear from the...
Well,
there's not any old default, it's a default which is
yes.
causative of the loss.
Well, yes, and in this case, as I've already indicated, my submission is the damage, the loss for which it is claimed, money is due, compensation is due, is the closure of the respondent's premises.
Can I just ask you, in the respondent's case, MS 111, paragraph 44, there what seemed to me arguably quite a helpful definition as how they put the word default. Paragraph 44 of the respondent's case. Either a person who has failed to act on a notice from the authority or a person who is responsible for the state of affairs giving rise to the exercise of the power in question. Now, do you dissent from that, and if so, how and why?
Well, the first thing to say is this isn't
depends on what you mean by the state of affairs, doesn't it?
Well, that is really...
You would say it's the admission of the public to your premises, and he would say it's the state of affairs of the peer.
Well, actually, I'd say that both of those catch the respondent here, because I'd say that it's the loading of the pier. The pier itself wasn't shut because works needed to be done. That would be, for example, under 1A of Section 77. But secondly, I'd say that the tenant also was responsible for the state of the pier. If he was in breach of legal obligations under the Occupiers Liability Act and or the Health and Safety at Work Act, and he shouldn't have been letting people in unless repairs were carried out, he was also responsible for the continuing defective nature of the structure, because he was continuing to admit people. He had a duty to make the public being admitted reasonably safe and its employees reasonably safe. And therefore it came under a duty, in fact, as well as the landlord, to repair the structure because of what it was doing on the pier. Yeah. And that is supported and has not been challenged by the decision in the Granada case, which I've cited, which indicates that the tenant plainly does have a right to carry out repairs, although he's not obliged to under landlord and tenant law, if the landlord doesn't do so within a reasonable period. And here the landlord had been told in a report prepared on behalf of Stylus itself, there will be an unacceptable risk to the public if repairs under that part of the pier were not carried out within at most a year. And the landlord had done nothing for 2 years.
Yeah, I mean, I understand all that. Why I found that helpful is indeed the point that my lady made. It gets away from worrying about whether the default is under the particular act, and indeed it gets away from the idea of what default means. Is actually what is the relevant state of affairs to which the default contributes. And the difference between you is actually that's what it's about.
What is the matter?
Which is the matter? I mean,
that seems to be the real dispute,
exactly,
rather than what's meant by default.
Exactly.
Right.
Well, the case as argued below, as I've tried to deal with it in my case, was argued and was accepted by the courts to restrict the meaning only to in breach of obligations under the Act. This point is a different point, never taken before, never taken anywhere, but I meet it head on because I say the person who is responsible for the state of affairs, the matter in respect of which action is taken, is the respondent, because he is the one admitting the public giving rise to the danger. And even if that weren't the case, he was under a duty to carry out repairs to the underlying structure he had power in landlord and tenant law to carry out, and he didn't do that. So 2 people are in default here, at least. The Act doesn't say only one person can be in default. It says any applicant for compensation who is in default shan't get it. What would be the position if Ravenclaw applied for compensation? The council wouldn't pay it. And the reason they wouldn't pay it is they'd say Ravenclaw was in default. What was it in default of? Not any breach of the 1984 Act. It was in breach of a private law covenant to repair the pier structure. It wouldn't have been necessary to exercise it in relation to the respondent's premises, or indeed in relation to the rest of the pier, if the repairs had been done. Ravenclaw is in breach. In my submission, also in breach in relation to the matter in respect of which the council takes action, is Stylus. It is giving rise to the need to take action because, as I've emphasised already more than once, if it's in breach of its obligation in letting people in, if it hadn't been in breach of that, the power wouldn't have needed to be exercised. Second, if it was letting people in, it was under a duty like the landlord, albeit outside the 1984 Act itself, to carry out repairs. And it's accepted it could have done that, and indeed it did do that. After the Magistrates' Court order was made, it carried out the repairs immediately beneath its own premises, and the order was varied to let the public into those premises, though not into other parts of the pier. And I don't have any difficulty with the way that the respondent puts his case in general sense, because I can meet that. But I do say that the need in law is to focus on the words default, and that the two meanings that I've given, although here Stylus meets each of them, are the legal meanings that ought to be applied when the words default in relation to are used, rather than caused by, causing. Well, could I make, again, the point that it's only when an applicant for compensation comes forward that one needs to look at whether he is in default or not, and deal with my Lord Toulson's point in relation to the notice sent out at the time. At the time, the council exercised its statutory power. It sent out a round-robin letter handed out to all the tenants on the pier, saying we're taking emergency action to close the pier, possibly to other people as well, I know not, such as ice cream vendors or whatever. That wasn't a legal document. The council weren't trying to analyse who was in default for the purposes of Section 106. There was no applicant for compensation under 106, and it wasn't a letter specifically directed to these respondents.
No, but it did explain what they were doing and why, didn't it? And it was issued by the communications and marketing branch of the local authority.
Yes, and it made clear that a
Do you
limited
have a
number,
page reference for that?
621, I was told.
It's part 5.
Press release is 622.
Um,
476 is the letter, or the note.
622, is that the MS number?
Yes.
Yes. So 476 hard copy number.
621 and 622, actually. That made clear that access to tenancies will be maintained and employees weren't prevented from going in.
Well, it tells us that the council has had concern for some time and had served a notice on the owner requiring to undertake a survey. And then what had prompted the action was that major events were being booked for the pier ballroom, July and August, and as a result of those, they'd done a further inspection and were closing the entire pier. Now, my question to you earlier was, would they not have taken precisely the same action if the amusement arcade had been closed? Because it appeared to me that the explanation in the letter made it plain that they would indeed have cut off the entire pier, whether or not the amusement arcade was open. You said, I think that was wrong.
Well, that is a letter directed to everybody, of course, on the pier. So it doesn't deal with the question of whether anywhere needs to be closed, if it's already closed or if it is a particular building or set of buildings. It's simply saying everybody's got to close because of danger. And it's true that what prompted the council's attention undoubtedly were these large events, which led to it then looking at the pier and saying, well, look, none of these repairs that were indicated by Stylus, and Stylus, as far as I know, was the only one with this 2004 report, that needed to be carried out within a year, or there would be an unacceptable risk to the public. Stylus had that, but it wasn't. The council wasn't focusing on the fact that Stylus had that and analysing legal niceties of who was responsible. It was simply saying, look, the pier as a whole has got to be closed. And they had investigated it, of course, because of these large events on the end of the pier. But that wasn't to say that the respondents' premises weren't dangerous when they were looked at. And they couldn't have been closed unless they were dangerous to the public. And they were closed on the basis that they were dangerous. And if Stylus was in breach of obligations in letting the public in, that notice in my submission doesn't affect that position at all.
Now, two pages.
Your point that, which
Sorry.
I put to you in response to me, that had Stylus's premises been closed anyway, they wouldn't have served this notice, doesn't seem to be supported by the facts. There's no suggestion that they went round looking to see which premises were closed and said, well, we don't need to close them. They clearly needed to deal with the thing as a whole.
None were closed. The only ones that might have been closed probably would have been Stylus's because they'd had the report earlier.
Yeah, but I mean, your suggestion that that was something which the council was motivated by is simply not supported. They very properly thought they had to close the pier as a whole.
Well, they did because all parts were open.
Could you
If all parts had not been open, although in reality they probably just would have issued a general notice anyway,
Yeah.
That's the reality of it. They wouldn't have needed to serve that on Stylus because his premises were closed, and they wouldn't have needed to put the barriers there, and the exercise of statutory power would not have been required in relation to those premises.
2 pages on, we get the entry from the Magistrates' Court Register. In the hard copy, it's 480, and it'll presumably be 624, I imagine.
626.
626. Okay. It talks about an attached plan. Do we have the plan?
We don't, my lord. In fact, we don't have a copy of the plan.
Because it prohibited access to the section of the pier south of a particular line shown hatched on the plan, and it's a bit difficult to understand that if you can't see the plan.
It was the area shown on the plan that I referred to attached to the statement of facts and issues. I can't say that was the plan that was attached.
Oh, but you can identify the area.
Yes. In respondent's evidence, it identified that as the relevant part of the pier that was closed.
So
The bandstand area was still open, beside, presumably that was above the beach, but
Yes.
everything beyond that was shut off.
Yes, there may have been the odd place closed on the bandstand part, but that was mainly open. No significant closure of that, as I understand it. And certainly no one suggested there's any relevance.
Sorry, on the plan attached to the statement of facts,
Yes.
you say that we can identify what was closed.
Yeah, everything that is beyond the
The light blue line.
light blue line.
That's a magistrate's closing order. Yeah.
Yes, it's what's called the central part of the pier, but that's because there's the pier apron with the bandstand on the wider section, which precedes it.
yeah.
And you can see where it is in relation to the beach and the sea on the top right-hand corner.
Yes.
Probably pick it up on the picture somewhere, wouldn't we? But I don't suppose it matters.
No.
So everywhere to the south of the blue line.
Yes.
Out to sea.
Southwards. I think Brighton faces that.
In my submission, which is the same general point, it's necessary not to focus on the council's conduct. It's necessary to focus on the respondents' conduct. And as I've said, they were the ones admitting people to those premises and the ones not repairing whilst they were doing that.
We've got to start with the council, because we've got to start by seeing what was the matter in relation to which the council exercised its power. Only when that has been properly identified does one then ask oneself, was the claimant in default in relation to that matter?
Yes, but the only contenders are the structure of the pier or the admission of public to the pier.
Those are the contenders.
Both are covered.
We can agree on that.
We can. I invite you to agree that both, or at least one of them, is covered here. The admission of the public, as I've said, was the responsibility of Stylus, and if it had legal obligations not to admit them, it was in default in relation to that matter, the loading. Second, even if the court comes to the conclusion it is the structure itself, but that doesn't in fact cause the danger, the admission of the public causes the danger. Even if it is the structure itself, Stylus was responsible as well for not having carried out repairs to that, because it was admitting the public and had a duty under the Occupiers Liability Act and a duty to the state under the Health and Safety at Work Act to make its employees and public safe if the public were admitted. And so whichever of the contenders is the right one, in my submission, Stylus was in breach here. But the matter was never analysed in that way by either court below. On the basis of the legal argument, obligations had to be under the Act. It was said the council had to pay compensation anyway, which of course would lead also to the payment of compensation by the council to Ravenclaw. Would it be helpful to the court to demonstrate on the facts how the respondent was alerted to the need for repairs under its units, failing which there would be an unacceptable risk to the public in 2004, or is that a fact the court is content to assume?
Well, if it's common ground between you.
If there's a reference you can give,
There's a reference.
that'd be fine.
Yes, I'll give the necessary references then, if I may, because at one point in the written case for the respondents, they do say that there wasn't a need for repairs beneath the footprint of the structure, footprint of the premises occupied by Stylus, but that is wrong, and I'll give the necessary references.
Is it in the statement of facts?
Well, this is the most argumentative statement of facts and issues that I think I've ever read. It's really quite unacceptable. But you're supposed to agree the facts and the issues. It seemed to be quite impossible for you to agree anything.
Not quite as bad as some would seem.
Well, my lord, my lady, this was never an argument in the courts below.
Well, paragraph 8 says something about what the claimant contends in relation to the 2004 report.
I think I should read the counsel.
Where are we going?
Well, my lord, I can give you the reference. My lady is looking at paragraph 8 of the Statement of Facts and Issues.
I am, because that appears to be suggesting something
Yes.
to the contrary of what you're saying.
No, my lady. What it says is the council contends, as I do now, that the 2004 report revealed urgent work was required to
It
repair...
says the claimant contends.
Well, it does, and he should say council. I've identified that, yes. But,
I mean, it's the appellant, i.e. you.
yes, it is. And that's perhaps clear. Obviously, it's completely wrong. That's gone down in that way. But the paragraph goes on to say the respondent contends at the bottom. So the first point is the council's contention, and the second point is the respondent's contention.
But I mean, it's quite clear. Everyone agrees that by that time, everyone was aware that the repairs needed to be done.
Yes, but this is 2004.
So
And
what's the issue?
Well, there may not be one, but that report revealed that repair work was needed, including to the structure directly underneath the respondent's premises, and I can demonstrate that on
No one
evidence.
seems to suggest that they were in breach of the Occupiers Liability Act at that stage by continuing to admit people.
No, because it said there would be an unacceptable risk to the public if the repairs weren't done within a year. And what it appears had happened when the council investigated this was that no repairs had been carried out, that Stylus hadn't looked at whether any repairs had been carried out. There's no evidence it took into account there might have been further deterioration or whatever, and simply carried on admitting people to the pier. It's part of the pier, which we submit was plainly in breach of its legal responsibilities, and you can't turn a blind eye or suggest that just because you were told it didn't need to be done for a year, you could carry on for 2 years and still not be in breach of your duties under the Act. So,
But I mean, but no one was suggesting that people using the amusement arcade were unsafe, were they?
well,
I mean, the council wasn't.
at the time,
They'd
that
have taken
wasn't,
some action if they thought they... There was we've got members of the public using an amusement arcade quite openly. There clearly are problems with the structure of the pier as a whole, but no one's saying that it's dangerous to use a particular amusement arcade.
Not until the time comes when the council, for other reasons, starts looking at which parts of the pier are dangerous and which.
So when do you say
are not.
they should, as a responsible owner, have closed their business, incurring all the losses that involved?
Well, I say that what they should have done was not necessarily close their business, but they should have made sure that the people were safe when they were being admitted. And that was in two ways. They could have first thought, well, I've had a report in 2004, it says repairs have got to be carried out within a year, or there'll be an unacceptable risk to the public. Have those repairs been carried out? It hasn't suggested that it thought they had. There's no evidence that that was the position. It didn't obtain a further report. It just carried on admitting people anyway. And the position is that it was admitting people when it was not heeding its own expert report saying that there was an unacceptable risk to them because repairs had not been carried out within a year, and it was not investigating whether there had been any further deterioration. And those parts wouldn't have been needed to be closed unless it had failed to do those things, which we say factually put it in breach of its obligations. And there were repairs required directly beneath each of the footprints of these premises, and the reports demonstrate that, and the 2004 report demonstrates that. And my Lord, that is the point that I was going to give the references to factually.
Yes.
Well, the first, my lords, my lady, my lords, the first reference is that the respondent, that's to say Stylus, received the first report in September 2004, and I draw attention to paragraph 61 of the 2004 report, which is at MS 218. My lords, in 6.1 on MS 218, Stylus's experts, structural experts, said the items recorded as failing have been grouped together on a single drawing in Appendix 3, and that's at MS 241. In our opinion, the failed items require urgent remedial works to protect the public and the pier structure as a whole. And in 6.10, in fairness, there's a qualification to that. It says, in our opinion, allowance should therefore be made for urgent repairs in the region of 1.2 to 1.4 million. The most urgent element relates to the repair of piles numbers given. Ideally, this should be carried out within the next 2 months to avoid the worst of the winter weather. The deck area supported by these piles should be closed to the public until this work is completed. With regard to the remaining work, that's the remaining urgent work, it is understood that this cannot be undertaken immediately. However, this work should be completed within 1 year with regular monitoring of the affected areas until this can be achieved. Unless this is carried out, we judge there to be an unacceptable risk to the public. So we're saying urgent repairs were required, and required at most on all the identified urgent areas within a year. And those repairs and the urgent works were shown at Appendix 3, which is MS 241.
MS4.
241, my lord.
That's the plan.
Is the
Oh, I see.
pull out
Drawings,
from the
drawings.
sleeve.
Yeah.
if the court wishes to look at this now, the relevant area, perhaps I can at least identify the relevant area, the place where the respondents' units were is easily identifiable. If you look at the trusses section, for example, because the pier apron is shown as the larger section coming out either side of the central section where the respondents' premises were. So it's possible to identify where the respondents' premises were from the plan attached to the statement of facts and issues. And they were just beyond the pier apron, and it can be seen, although the markings are not the clearest, that there's a key to trusses, and it shows in particular truss replacement required by reference to a box to the right of that plan, and a number of solid bold lines showing trusses where replacements required, and a number of other defects which are shown in that area. And that's just in relation to the trusses. And that is in the area directly beneath the bingo hall, and it is directly beneath the amusement arcade, as well as the central walkway.
You say it is beneath the arcade, but...
Yes, because if you look, for example, at 200 to 201, where it's got broken diagonals...
Yes, I see, yeah.
There's a solid line showing truss replacement required and broken diagonals and so on. And similarly, a large number of those in the bingo hall above. And those are described on the top of the plan as urgent remedial works required, identified in September 04. And as I've described, it was said that if they weren't done over the year, it would be an unacceptable risk to the public. So to say that repairs weren't necessary beneath the footprint of the respondent's premises, as is said in its written case, is not in my submission box. As at summer 2006, when the Council exercised its statutory power under Section 78, none of those works had been carried out. And there's no evidence Starless thought they had been.
So no evidence?
No evidence Starless thought they had been.
No, I mean, they were trying to get the owners to do them, weren't they?
Yes.
And they failed.
Yes.
You say at some point they should have done something different. I'm not quite sure what, but
They should have not let people in because
I mean, that's basically at some point they needed to take a decision. It's not safe to let people in.
Yeah. After a year with nothing done, there was an unacceptable risk, and that means you don't let people in, or you do the repairs yourself. My lord, that they weren't done is shown, and I can perhaps again just give...
And are you asking us to decide this is a question of fact, or are you saying this is an area which should have been investigated at first instance, and therefore we should send it back so they can decide whether there was default, at what point there was default, and so on?
Well, it wasn't decided at first instance. The court simply decided this isn't within the Act, only breaches within the Act will do.
So we'd have to remit back, if you're right.
You would have a choice of either, unusually, saying this is, because this is so very clear, there's no need to remit back, they were in breach, or you would remit back to say it needs to be investigated further. But the court needs to bear in mind this was a Part 8 claim. The Part 8 claim is determined on paper. So the court below will be in no better position, actually, because although it would be a more normal task for that court, it would have to decide it on paper, as invited to at the hearing of the Part 8 claim by the respondent, on the evidence that is before it.
I mean, an alternative view is that these are rarely matters for the arbitrator assessing damages, and that actually what's intended is you look first to see, is there default which actually was causative of the council action? And that's a relatively straightforward question, because you see, why did the council do what they did? And that's clear from their notice. Then, when you get to the question of compensation, you obviously have to assess whether they would have had, whether they could responsibly have gone on using the building anyway, and that's relevant, and the arbitrator can go into all that.
Yes,
It's certainly pretty odd to see it being dealt with
yes.
the paper.
That's really a different question I would submit in relation to how the losses come about, and we'd certainly have those arguments available to us, as the Court of Appeal said. But the question here is, were they in default? And if they were in default...
You see the point. The difference is you look simply at why the council did what it did, what caused that. That's a fairly narrow question, which you can find out from their document. The more general questions of whether they were in default in some way under the Occupier's Liability Act or this, that and the other goes to the question of compensation and needs to be dealt with there.
Well, in my submission, it's not about what caused it. In a sense, it is. But if the respondents were in breach of their legal obligations, and it wouldn't have been necessary to exercise the power but for those obligations, they are in default. And
No, I understand that's not your case. You're saying any default is good enough. All I'm suggesting is an alternative view, which is not the way you're putting it, but might be more attractive, because it would ensure that one doesn't get bogged down in these difficult factual issues in deciding whether there's a claim for compensation at all, would be to say that these matters are really matters for the arbitrator.
Well, the arbitrator is to decide on the amount of compensation, and the question at this stage is about default. And if it is the case they were in breach of their legal obligations, they shouldn't be entitled to any compensation. Council shouldn't have to go to the expense of that exercise. The arbitrator shouldn't be inquiring into it. There is no basis for them being awarded compensation because they are in default under the Act. And if I've demonstrated...
Well, I mean, that's your case, and we've got that.
Well, my Lord, it is in our submission very important that it's not left to the arbitrator, because there are limited grounds of appeal from arbitrators. There are all sorts of things. This arbitration is imposed statutorily. It is not a consensual matter between the parties.
Which is the section which...
It's section 106.2, subsection 2.
Thank you.
It's at MS page 909, 910.
So there's no limit on what he can inquire into.
Well, what he's concerned with looking at is what happens after the exercise of the statutory power on the basis the appellant is, or respondent is within the provisions of section 106.
Yes, but obviously if it becomes apparent that they couldn't have gone on occupying it because it would have been unlawful to do so, then you can take that into account.
Well, the respondents would say so. The appellants would suggest not. They would say, and rely on the words of the Court of Appeal, that the arbitrator, like the court, does not need to inquire into whether the respondent was in breach of his legal obligations. And the Court of Appeal say that in terms in their judgment.
Where do they get that from?
Well, that's what I was rather wondering.
Paragraph 95, MS 161, I think may be relevant.
Yes, that's the...
Thank you.
Yes, it's paragraph 79. It's on page 159. Having considered council's competing submissions, I come to the same conclusion as the judge. The phrase in default means in breach of an obligation arising under the 1984 Act. Provision doesn't require the court or the arbitrator to conduct a wide-ranging review of other legislation and the common law in order to see whether the claimant is in breach of any duties arising outside the 1984 Act.
Sorry, where were you reading?
It's paragraph 79.
79, I thought.
And of course, with regard to paragraph 95, the...
What does that mean, 79? Because you don't get to the arbitrator if there's a default.
Well, exactly. And that's why I say that the court, if it's satisfied a breach of legal obligations, whether that be the High Court on remission or this court, doesn't let the matter go to the arbitrator because it is in default. Because of breach of legal obligations. But the other side, no doubt, would say, well, if the court has decided it's not in breach, it doesn't make any difference whether it's in breach of legal obligations, then it doesn't make any difference.
But I don't understand, I mean, that is, I can understand that as applies to the court, but the arbitrator, in paragraph 95, it accepted that the arbitrator can inquire into whether the structure would have affected the business. So he's saying there you can look at what the effect would have been on the business, which I would have thought was clearly the position.
Well, my lord, certainly it will be our argument in the arbitration, but that doesn't mean to say that I shouldn't take the point here, and it's not right.
But just to understand what the Court of Appeal is saying, in 94 they're saying if you haven't got a relevant default, you're not going to exclude in principle a claim for compensation based on ex trope causa. But then then Lord Justice Jackson qualifies that by saying, but in front of the arbitrator, the structural condition isn't irrelevant because having not let in occupiers' liability and health and safety at the first stage, at the gatekeeping stage, it comes in at the quantum stage.
Because you couldn't run your business if you were in default of, or at least you couldn't legally run your business.
Precisely.
If you're in default of legislation, and therefore you couldn't legally incur a loss of profits.
Of course, the claim's not now just for loss of profits, but
No.
I don't know what arguments will or will not be ranged against me in the arbitration.
No, but I mean, I think the point is that in paragraph 79, the inclusion of the reference to the arbitrator seems a bit odd because it doesn't really fit in with what he's saying in paragraph 95.
Yeah.
Well, that may be the same, my lord, but his starting point is actually the same as mine, that if someone's in breach of their legal obligations...
Oh, yes, I mean, your point is under the Act, default. We've got that very clear. I understand that. All one's putting to you is that even if you, you would accept that if you fail in your principal argument, then you'll be able to deploy all these points in front of the arbitrator. And you're saying that that's what you'd do.
Well, I'm not only relying on causation, I'm saying there's a second limb to this anyway, that even if there wasn't causation, where the exercise of the power prevents someone from doing something he shouldn't have been doing in breach, then again he's in default. So it's not pure causation.
No, I understand that, but,
But
you are going to argue.
If you lose that argument, you've still got an argument that there cannot have been any legal liability. Couldn't have been any legal loss of profits. I mean, I think that's the point, isn't it? I don't think one needs to elaborate on it.
I don't know what the arbitrator will think of that or not.
Goodness knows, but I don't think we have to worry about it now.
I'd sooner that the court looks at the words in default
Oh, yes.
and says, what do they mean?
Get back to your original argument, yeah.
And is the respondent out at this stage? And I'm giving the factual references which show why he was in breach of the Occupiers Liability Act. It may be that has to be remitted to the High Court if necessary to be determined, but the Court of Appeal and the judge has said we don't need to inquire into that because the statute says that if you are not in breach of the Act, you should not be deprived of compensation. And similarly, my learned friend says that he should not be deprived of compensation for the reasons he gives. But the reasons don't add up because on his own case, the matter in question is either the loading, which the respondent was liable for, or the defects in the structure. And if the High Court needs to inquire into that and whether there was a breach of duty, so be it. But it's a matter at this stage in my submission. I shouldn't be thrown on the mercy of the arguments that might arise in the arbitration.
No. I think I sort of messed it, so tolerably clear by now.
But I won't say any more about that. I've given the references.
Haven't we got the point?
Yes, I'm going to move on, my lady, to the further references in the facts. Okay. I just referred to the fact that Starless's own July 2006 report, which is at MS 303 onwards, shows the same defects were still there when the council exercised its statutory power. It's MS 241.
MS2.
No, I'm sorry.
MS241 is the big plan.
It's Appendix 3 of the 2004 report.
So sorry, you'd need to compare that at 241 against 303 to 305, MS 303 to 305. And the trusses are at 304.
But I mean, that's hardly surprising if no one had done any repairs.
Well, that's all I'm demonstrating, yes. And what caused the exercise of the statutory power in relation to the respondent's premises, the exclusion of the public from those was in fact the defects there. And the council's closure report, page 259, MS 259, paragraph 4.3.1, and paragraph 6.1 show that it was defects in what's called the central section, which is where the respondent's premises were.
Could you have the paragraph numbers again? I'm so sorry.
Yes, it's MS 259,
Yes, I have that.
which is paragraph 4.3.1, and MS 262, which is paragraph 6.1. And it will be seen in 4.3.1 that there's reference to the central area, and effectively it's said that the whole of that central area is dangerous because the laid paths that would be available but for the defects are not available. And in particular it refers to the area bounded by columns 197, 216, 211, 200, see figure 1.
So what's meant by crowd loading?
Well, the council say that it was the public. You can't control how many people go into the bingo hall or the amusement arcade, and several hundred may do that in the course of a day, as the claim for compensation suggests. And the public were the ones excluded. The signs didn't exclude employees. The notice issued at the time didn't exclude employees. And it was loading by the public, which is why they took steps to prevent loading by the public, which would have resulted in unknown numbers of people entering premises not sufficiently supported to carry the load. And those premises themselves, of course, were dangerous. It said the structure was dangerous, but if premises stand on an unsafe structure, then those premises are also dangerous. But the point at the moment is that they were in this area. And it says look at figure 1, and in fact the columns that are referred to there, even 197 to 200, were in the area of the respondents' units. Figure 1 hasn't come out well on the copy at page 256. I'm not going to take the court to the detail of where the trusses were unless you want me to do that, but I will provide a better copy of page MS 256, so that if the court wants to look at that subsequently, it'll be available to it. Could I hand out copies in case the court wishes to look at that at its convenience? I'm not suggesting you do so now.
No, let's not bother now.
No. So, my ladies, as far as the Occupiers Liability Act goes and the Health and Safety at Work Act go, the respondent, we say, plainly was in breach, and the argument that it wasn't the occupier of the underlying structure is neither here nor there for two reasons. It's flawed because, first, the premises the respondent was an occupier of were themselves unsafe because they were standing on a structure which couldn't cope with the loads put on them by the public. And in that connection, could I just refer the court, without taking it to it, unless he wants to do so, to the case of McDowell against FMC Meats Limited, 1967 Knights Industrial Reports, page 595 at tab 19. The head note itself will suffice. If the court wants to go to it now, I'm very happy to go to it.
Well, it's you who want us to go to it.
Well, I do, but I'll take you to it in court rather than you looking at it privately, if that's convenient.
If you want us to look at it.
Would you look at the head note?
Which page are we on?
It's MS 1697.
And what's the proposition we get from it?
That something off the land that the defendant's got no control over, and which he's not himself in occupation of, can mean that the land itself is unsafe. It's a fairly obvious, I would suggest, proposition, and in that case, an electricity board had a high-powered cable running over land. The occupier of the land wasn't himself able to do anything about that cable. He wasn't in occupation of it, but it was something that made his land not safe unless he did something in relation to it. And in that case, he simply had to issue warnings, probably, but whatever he was supposed to do, he didn't do. He did nothing.
I mean, your proposition, as I understand it, is that if through circumstances beyond your control, your land isn't safe and you can't do anything about it, you still have a liability as occupier, because what you should do is not allow visitors to come onto your land.
Yes, it is to that point.
Yeah.
But here they could have done something about it by repairing.
But even if they couldn't do anything about it, you'd still say they had they were in breach in allowing people onto their land.
Yes.
Yes.
But what if it would be okay if they limited the numbers of people coming into their premises?
Well, if it had only been their employees, for example, the council wouldn't have had any difficulty with that because they allowed employees in. Whether a bingo hall can operate with just a few people, I rather doubt, but I don't offer evidence on that point. But there was no suggestion they were limiting it, and the report just said unacceptable risk to the public. It didn't say it'd be okay for 10 or 20 people.
Well, I'm still worrying about what's meant by crowd loading, that's all.
Well, my lady, it's not been suggested the power wasn't lawfully or justifiably exercised, and what it prevented was the public. And the public gives rise at least to the risk of crowd loading, and its risk that the Occupiers Liability Act is guarding against, and especially the Health and Safety at Work Act. Secondly, as a separate point, what the respondent was doing on the premises itself was unsafe. This is the point that has just been mentioned by Lord Hodge, because the duties under the Occupiers Liability Act include things done by the occupier on the premises, as well as things to make the premises themselves safe. Section 1 of the Occupiers Liability Act, of course, replaces the common law duty in relation to things done on the premises. So it has been said in the past, for example, by Lord Hoffman, that if you organise shooting on your land, that might constitute a breach because you're doing something on the premises which renders people coming onto them unsafe. And here the respondent was admitting people to the premises generally, which meant they were unsafe given the condition of the structure below. It wasn't just admitting one member of the public, it was admitting members of the public generally. So it would be in breach under subsection 1 of section 1 as well. And similarly, in relation to the Health and Safety at Work Act, and there the position would be, in my submission, even the stronger, because that's a duty owed to the state. The case of Queen against the Board of Trustees of the Science Museum is one which we rely on, which is at MS 1725, tab 22. And that confirms that it's all about risk. And I invite the court to read the headnote of that decision of the Court of Appeal, which is at page 1725. And the relevant part in the judgment is at page 1731, paragraphs F to H.
Yes.
And it's right in my submission that the burden should be on, as Parliament has put the burden on, the person letting people in to make sure that it's safe. The fact that under the Occupiers Liability Act no liability had been incurred because no one had yet been injured or killed when the power was exercised is irrelevant to the question of breach. The respondent says no liability was established, but that is not the question. Similarly, under the Health and Safety at Work Act, there was no conviction. But that is not crucial. Its own case of Hobbs and Winchester Corporation shows that. It relies on that in relation to the point made by the Court of Appeal that it in some way supported the suggestion only breach of obligations under the Act would do. But in that case, the person in default had actually been acquitted on a criminal charge of the default that the court said, actually, there was. He had been in breach of his obligations. And similarly, in the case of BOC against the Health and Safety Executive at tab 13, various notices have been served under the Health and Safety Acts by the Health and Safety Executive on someone else, but nonetheless, the respondent, the defendant, was held liable because although he'd not been served with a notice, he knew what the position was, and he knew there were risks to his employees. And he allowed his employees to go onto someone else's land in circumstances where they were in danger in the way in which operations on that land were carried out. Manolete, Hobbs and Winchester brings me back to the what started off as being the basis for this appeal. And I haven't actually argued anything at all, I think, about the question that the Court of Appeal raised. I started off by saying that the words in default couldn't be limited to breach of the Act itself, and we got to the point where my submissions suggested that the plain reading of the Act would show that default covered any breach of obligations. Allied to that, I suggested that common sense would support that construction, and I suggested there was a purpose to Section 106 and its caveat, which meant that people in breach of obligations should not, as a matter of principle, be entitled to compensation. I would add to those points, if it's necessary to do so, the fact that public policy would support my suggestion also because it would encourage people to carry on taking risks until they were stopped. It would discourage the council for preventing risks until they were absolutely sure that they needed to do that. And the other legal arguments, and what's said in reply is the council could insure itself against those things. But it would be very difficult in my submission. There's no evidence to show the council could insure itself against such wide-risking unknown risks. It knows not what dangerous places might arise in its area. It knows not what the claims might be. The insurers would be in difficulty in assessing the degree of risk. But even then, if it came down to insurance, if anyone could claim, even if they were in breach of obligations, added to all those things, the premiums would be enormous if it was obtainable. But the basic point is, why on earth should the council have to insure itself against paying out compensation to people who are in breach of their own legal obligations? It's also said, well, you could exercise your Section 77 power more quickly perhaps. But the fact is, if there's an immediate danger, you take action when the immediate danger comes to your attention. You could perhaps have been swifter about it, you could perhaps have been slower about it. You do what is right when it comes to your attention, though. And when it comes to your attention, you take the action, and if people have been doing something wrong, it's them who are applying for compensation from you, and it's Parliament saying they are not entitled to the compensation if they have been in default in anything. And it necessarily would precede a Section 77 order because there's no need to exercise the Section 78 power if you've got a Section 77 order. The next point, if further reinforcement is needed, is in summary that the construction taken by the Court of Appeal would enable people to benefit from their own breach of obligations. And I've referred to the case of Well in Hatfield, which will be well known to this court. The decision in Well in Hatfield is to be found at tab 24, MS 1748.
What exactly are you getting out of?
Well, my lady will remember that's the case where the person built what appeared to be a hay barn and it came to be a house. And the
He managed to keep that fact concealed for 4 years.
managed to keep it concealed for 4 years, and read absolutely on its face. The Act, Section 171B of the Town and Country Planning Act, said that 4 years was absolute. If action wasn't taken, the council was out of time. And so
How does the heroic decision of the Supreme Court in that case help in this case?
Well, I submit
Your
because
matter of statutory construction and application to the facts.
yes, I'd rely on.
Used to that one, you're not doing terribly well.
Sorry.
If you're reduced to relying on that, you're not doing very well.
That's why it's my, I think, fifth or sixth point, I hope. But,
Anyway, I think we understand the point.
yeah, just for the references, it's paragraphs 45 and 46 in the judgments. And it doesn't just come from Well in Hatfield, it comes also from their quotations from Benyon and Holsbury's laws. But it's a basic point of legal policy. Law should serve the
It
person.
doesn't apply here, because as I put to you earlier, the Act accepts that even if someone is in default, they may still be entitled to compensation because the authority weren't entitled to shouldn't have used their power under 78.
Well, certainly.
So there's clearly no general proposition that you can't claim merely because you're in default. If the authority weren't entitled to use their Section 78 power, then you can.
Yes, well, that's undoubtedly so.
So there's no sort of general thing. One's just got to look at the statute and see what it means.
But if my argument failed on all the grounds that I've advanced so far in saying that default includes where you're in breach of your legal obligations, if it was said default had some other technical meaning on the face of the statute, I would then have to resort, which I accept I don't have to do, to Well in Hatfield to say, well, you shouldn't construe that literally and let people in breach of their legal obligations have compensation. But I'm perhaps pressing a point that on my own case doesn't need to be reached.
It's always better to concentrate on the good points rather than the less good ones.
Well, could I raise another good one, and that's the legislative history. I'm not going to go through it, but at the time when these words were first used, it must have been intended to include obligations other than under the Act the phrase was used in, because otherwise a plethora of local acts where people would be in breach for building dangerous buildings or admitting people to them wouldn't have made any difference when Parliament said you still get compensation for your closure or whatever unless you're in default, and Parliament can't possibly have intended that. I've dealt with all that, we've dealt with all that in our written submissions, and I won't take it any further. The other point, though, that is raged against me is that in section 77 there's a reference to default, and in section 78 there's a reference to default, and it said default should be construed consistently throughout all the sections of the Act. And in sections 77 and 78, the person in default is in default of a legal obligation under the Act. That, in my submission, doesn't make any difference at all, and it only comes from the specific wording of section 77 and section 78, where they use the word default. Section 77 is at tab 2, MS 883. And what's relied on against me is that at section 77.2, it says if the person on whom an order is made under subsection 1A above fails to comply with the order within the time specified, local authority may execute the order in such manner as they think fit and recover the expenses reasonably incurred by them in doing so from the person in default. And the point here is made, the person in default must be the person who's not complied with the order. I entirely accept that. That's what the wording of the sentence says. It doesn't say that in 106. It doesn't have any point of direction, that it's only someone who's failed to comply with a breach of a particular obligation.
In any event, the word there only applies to one specific default, as you say,
Exactly.
the subsection 1A, so it can give no guidance whatsoever about the use of the word in 106.
Exactly, my lord. Thank you for putting it so well on my behalf. Similarly, section 78(7) is relied on.
And that's simply a reference to 106.
It is.
Again, tells you nothing.
Nothing at all. My lords, those really are my submissions, but I'd end by urging the court not to say all this should simply be inquired into by the arbitrator. And if breach of obligations is sufficient, contrary to the findings of the courts below, the matter either should go back to the judge to decide whether there was a breach of obligations, that is to say a default or not, unless, unusually, this court is prepared to say the evidence is so clear that there's no point remitting that, given that it was a paper determination. My lady, my lords, are there any other points that I can deal with?
I think you've had quite a few thrown at you already, so I don't see any more coming your way. So thank you very much, Mr. Gasworth.
Thank you.
Mr. Parker?
No.
Mr. Badry?
If I could begin by giving perhaps two references, the definition of premises in each of the leases. The first is MS 581 and the other is MS 607, which deals with the point Mr. Thompson was making. If I just take the other lectern for a moment, please. Can I say at the outset that I came to this matter somewhat late in the day, and I agree with the relationship. It is a short point, and it's a relatively simple point of statutory construction. And it has been, unfortunately, somewhat overcomplicated. I think part of the problem we perceive is that the overcomplication has been trying to turn a Part 8 claim into a Part 7 claim, with various findings of fact which are not relevant to the proper construction of this statutory provision, but may be relevant in any future arbitration. If I could turn to MS 160, the judgment of the Court of Appeal, beginning at paragraph 90, please. At paragraph 90, Justice Rupert Jackson says that this is now returned to the present case. In June and September 2006, the pier was safe for use by a moderate number of people, but not safe for carrying large crowds. Despite an erected barrier on the 16th of June, the council permitted stylists and other defendants and the various employees to walk along the pier. As previously explained, the motivation of the council for closure of the pier to the public on the 16th of June was the likelihood of large crowds accessing the pier on and after 17th of June for reasons unconnected with Styles' business. 16th of June, Styles not incurred liability to any member of the public for breach of Occupiers Liability Act 1957, nor can I see any basis saying Styles have committed any breach of the statutory duties which are owed to the employees under the Health and Safety at Work Act 1974. More importantly, however, even if Styles had committed a breach of the 74 Act or someone failed to exercise due care, that did not trigger the operation of the ex-turbine causal law. And then he goes on, so the short answer to the second ground of appeal, which I don't think has been pursued. But 95, having said that, I do accept the structural condition of the appeal be relevant to the quantum of the claim, the council will be entitled to argue in the arbitration due to be held under section 106.2. The loss of profit caused by the council's conduct must be substantially reduced by reason of the structural condition of the pier. Indeed, the council will be entitled to argue the quantum is reduced to nil, though on the evidence which I have seen, that outcome seems unlikely. Now, we would submit that most of this morning has been taken up to try and persuade your lordships that the findings of fact made by the Court of Appeal, which were reinforcing the findings made by Mr. Justice Ramsey, were somehow wrong and cannot be justified by the evidence. But the difficulty...
Justice Ramsey did he deal with that aspect?
At first instance.
The occupier's liability.
I
thought he just said that because it wasn't a default under the Act, it wasn't relevant.
We just go to... he deals with at page MS 175. You see paragraph 48. It's not suggested on behalf of the council the claimant is in default of any of the provisions of the Building Act, rather than the council relies on default under other statutes. And then he, at the bottom of 51, I do not accept the submission by Mr. Gasowicz. It cannot have been the intention of the legislature that the person in default of occupies liability of health and safety could invoke the benefits of section 106. In my judgment, the intention of the legislature cannot have been to consider default under other statutes.
I mean, I think
Therefore, he doesn't actually make...
it's not irrelevant, whatever their default might have been under these other acts. It doesn't come into it.
He dismissed it as being irrelevant rather than finding
But you're entitled to rely on what the Court of Appeal found.
Paragraph 92, I suppose.
And the difference my own friend has is that on the Part 8, he didn't submit any evidence. All he did was serve a defence. If you just bear with me, because I've lost my reference to the amended defence or original defence. I think it would be helpful if we could look at that.
Is this the document at page 501?
It's in part 4 of the appendices in the hard copy, page 356.
Yes.
And the
Same thing I'm looking at.
Yeah. It raises all sorts of issues about their default.
We go to MS 356 then.
It's not,
No,
it's not MS,
501.
it's 501.
501, I am grateful.
The amended defence actually is at 49 onwards.
So where is it in the hard copy document?
It's at MS 193.
In the core bundle?
In the core bundle, appendix part 1, page 51.
Sorry, thanks.
Which do we want, the original or the amended?
I think the original will suffice.
The amended was the one that presumably went to trial.
Yes, can we go to the amended? Can I have the reference again, please?
MS 193, in the core bundle, MS
193.
193.
Great. And we go to paragraph 9 at MS 195. The defendant was forced into that position by the following circumstances. We go over the page, in particular paragraph 11. The defendant held an internal meeting in respect to the pier on the 12th of June. At this meeting, it become clear the event was planned for the pier ballroom, nightclub and pub at the end of the pier, which had the capacity to attract up to 1,800 paying customers. Malcolm Clark, who was a representative of the council, advised at this stage that the safe loading capacity of the pier was unknown. He was very concerned that the mass excavation would lead to a partial collapse. It was agreed that Giffords would inspect 2 specific areas on the main route to the ballroom, which had previously been drawn to the attention of boss management. Now we see that the report which was produced by Gifford, there was an earlier scoping report in April, but the report which was relied on for the closure of the pier, we see at MS page 249. And it's paragraph 1.1, page 108. This is the following submission of the report, that's the April report, which is in the bundles. The council was successful in serving an improvement notice. Subsequent to serving the notice, the council became aware of the forthcoming series of events with potential attendance of up to 1,500 persons per event. There was no evidence of the information, action plan and programme of works required under the notice. would be provided prior to the first event being held. People were requested to undertake a more detailed independent inspection of specific areas of the pier. And their conclusions were, at page MS 262, access resulting in potential for crowd loads on the central section beyond prohibited. This is paragraph 61A. It's likely as a minimum the presently identified defects in the area of the central section bounded by those columns have been rectified. Alternative safe access routes have been provided. Access by shop tenants, others for purposes of maintenance being restricted. Effective areas of parade extension should be cordoned off. Now we would say the Court of Appeal are quite right to say the matter which led to this closure of the pier was the concerts which were planned at the end of the pier, and they're concerned about crowd loading if there had to be a mass excavation. Now my learned friend says, well, that may be correct, but you were in breach of this, that and the other. But that's not really a matter for your lordships and ladyships. That's a matter of the arbitration. If it's be said we couldn't have carried on operating the bingo business or the amusement arcade business because the pier was unsafe, irrespective of the risk of crowd loading through mass excavation, that's a point you can take in front of the arbitrator. Certainly not a point that should be taken in the Supreme Court, where you haven't got the benefit of evidence or expert evidence which can be cross-examined. So we think that your ladyship mentioned the statement of facts was controversial. That's because the facts are controversial. But those are matters which must be resolved by the arbitrator, not by your lordships.
I think I said it was argumentative.
Argumentative. Well, I apologise for that. In terms of my submissions, I think I can take them fairly briefly. Hastings' case before you today is really a simple point. He submits the court below urging law and find the phrase in default in section 106 of the Building Act 1984 means in breach of an obligation arising under the 1984 Act. It's common ground. We're not in breach of any obligation under the 1984 Act. We would invite you to construe section 106 as Ms. Justice Ramsey did and as the Court of Appeal did. And that is the end of the matter.
Very good.
Now, the Court of Appeal had a split hearing because there was an order made after the first day that the Court of Appeal wanted to have detailed submissions on the legislative history behind section 106 of the Building Act 1984. Well,
is it right or is it necessary to construe it so narrowly? And supposing that the state of the premises constituted a statutory nuisance within the meaning of section 79 of the Environmental Protection Act, and suppose, for the sake of argument, that the applicant for compensation was responsible for that public nuisance. It would be a bit odd if he was entitled to compensation and could say, well, I'm not in default in the meaningful sense because my legal liability is one for nuisance, which either arises under common law or under the other act, not under this act. That would be over narrow, wouldn't it?
if it's a statutory nuisance, then he would be in default and therefore would not be able to claim compensation.
Yeah. Although that particular default wasn't under the Building Act, it was a default arising under a different statutory scheme, but one in pari materia.
Yes. But again, in terms of looking at the development of the legislation, the statutory nuisances were introduced as part of the Public Health Acts, and compensation was paid insofar as a party suffered from that statutory nuisance.
And if you concede that a default in relation to statutory nuisance could be capable of being a default within the meaning of the compensation section, the same would also apply, wouldn't it, if it were common law public nuisance?
We're being walking into a trap. I think that must be right.
It doesn't affect other parts of your argument, but it may be that the courts have adopted an over-constricted approach.
But going back to section 78, we would submit it's tolerably clear that a default which justifies compensation under section 106 must be a breach of an obligation arising out of the Building Act or arising out of the dangerous condition of the property for which we were not responsible. I think it's important to realise that we had no responsibility for the structure of this building. We were the innocent party and actually provided a report agreed and commissioned to both the landlord and the council. Nothing had been done with it. The only thing which provoked what we regard as this perhaps overreaction to closing the entire pier was the threat of crowd loading caused by the risk of a mass excavation, a concert held at the
I think you mean evacuation, don't you?
evacuation, yes.
Again, as a matter of pure construction, not suggesting it bites on the facts of this case, I wonder if it's right to say you can narrow 78 to simply a case where the state of the structure is dangerous and and therefore that leads you to focus only on who is responsible for that dangerous structure, because you could have a situation where there's nothing inherently wrong with the structure for the purposes for which it was intended, but a particular occupier uses them in a way which grossly overloads them.
Yes.
Now, there, the problem would arise not from the inherent structure, but from the overload, and the party responsible would be the overloader, wouldn't it?
Precisely.
Yeah.
And there was a suggestion I was picking up this morning that we could be responsible for that overloading by inviting our bingo customers to come into our bingo hall. But it's quite clear from the factual background to this case that risk of overloading was for the concerts in the ballroom at the end of the pier.
No, well, we haven't exactly had a camel's straw argument.
No. And it's
No. Yes, but you're accepting, if you look at 78.1, that it's not just the structure, but it's also the use, and if there is overloading that causes danger, that could be a default. But you can pray and aid the findings of fact of the Court of Appeal in respect of the two statutes on which the council founds that there has been no, in the Part 8 claim anyway, no demonstrated breach.
precisely.
You said...
It's also not only those findings of fact, but also the way the case was pleaded and was originally wrong.
True it is that the order made by the magistrates was under 77(1)(b), because that was what the summons was brought under, although one might have thought that the reality was that the relevant section was 77(1)(a). But, you say, if you're looking at it in 77(1)(b) terms, overloading rather than underlying structure, the relevant overload, which was bothering the council, was the prospect of well over 1,000 people coming to an event and the possibility of a mass evacuation, that plain not merely from the report, but, you say, from the other side's pleading.
Yes. And those are findings which they're fully entitled to make, and they're consistent with the way the case was been pleaded and the way in which the council dealt with their concerns by commissioning a further report. And it's consistent with the press release and the letter they sent to Stylers apologising for closing the pier. Now, we also take the point, well, the council should not have waited to the last minute to close the pier. They had all the relevant material to press the landlords to carry out repairs earlier. They should have pursued the landlords.
That's quantum point, isn't it?
It's all quantum. But in those circumstances, we say that on a simple construction of section 106, we're not in default. Now,
Because either it's the structure and you're not responsible for the structure, or it's the massive overload and you're not the massive overload.
exactly. And your lordship's seen the definition of the premises. It's quite clear that we have no responsibility for the structure either below our premises or above our premises. And as I think the Court of Appeal found that Stylers acted reasonably at all times in drawing the attention of the council and the landlords to the structural condition of the pier, which wasn't affecting our business but should be looked at, and remedial works should have been introduced. Now, if and insofar you'll follow the path adopted by the Court of Appeal and find the legislative background helpful, We would invite you to look at the Metropolitan Building Act 1844, Section 42.
We offer a choice. And it seems to me, I don't know to what extent you are pressing the argument that it's only a default under the Act. I mean, you said you were adopting that, but it's very difficult, isn't it? I mean, this sort of compensation provision has been around for donkey's years, as the history shows, and it's been used in statutes which cover a whole range of things, and it's fairly arbitrary going back over history, whether the particular things like the building regulations are in the Act, the Public Health Act, or are in local legislation. It'd be terribly odd if Parliament was really trying to confine this default to something which happened to be under the umbrella of the particular Act at the particular time. I mean, what would be the point of that?
Well, that's why the historical development may be helpful, because certainly this compensation provision was introduced to provide compensation for the additional statutory powers that would be given to local authorities to serve dangerous structure notices or shut down buildings.
Yes, but obviously a lot of the cases are concerned with that sort of situation. Yes. But why should... It's because, in fact, Lord Justice Aikins was...
Ramsey, yes.
In this case, the Court of Appeal was saying, well, this Act or related Acts. So they don't actually confine it to this Act, because they realise that would not make any sense.
Yes. But I think if we're going back to Section 106, if it was going to be default under any Act, then clear word should be said to that effect.
Well, and I thought you've dealt with the cases in your very helpful case, but Clayton and Sale was, I thought, quite an instructive case, although it's not on this provision, it's talking about default. And there it was being argued that the only relevant default was default outside the Act.
Yes,
and that was rejected robustly by the Divisional Court.
Yes.
But, I mean, there's no suggestion there, and indeed the whole basis of that was that your common law duty to maintain keep your premises, avoid them causing a nuisance, was enough to be default under the Act.
Yes. But I don't want to press a bad point, but we do say the simple construction of this Act is you must establish, we would say default under the Building Act, we stand by the construction adopted by the Court of Appeal and the judge below. But if it is default under a related Act, there's clearly no evidence to challenge the findings of fact made by the Court of Appeal that were not in breach of any related Act. It can't be much shorter than that. And although my learned friend may think those are unreasonable findings, the Court of Appeal did make it quite clear that he can take those points in the arbitration. And that is the appropriate form for those points to be taken.
Which, as I was saying earlier, means the mischief of someone being compensated for doing something for profits earned illegally would not arise if it were proved against you in an arbitration that you should not have had the premises open because of the condition of the trusses underneath your premises.
Precisely. Yeah. Now, we regard that as extremely unlikely, because even the council are prepared to allow people to come onto our premises for maintenance and generally looking after the premises. That's an argument for the arbitrator, not for today. I don't know whether I can assist you any further, but it is a short point, and we would invite you to dismiss this appeal.
Thank you very much, Mr. Brown.
The reply will be commensurately short, you'll be pleased to hear. The Court of Appeal was not the first instance court, and it did not inquire in detail into the evidence in relation to whether there was or was not a breach of the Occupiers Liability Act or of the Health and Safety at Work Act. Indeed, an attempt to pursue these points was met with some disinterest, with which the court might feel some sympathy here, on the basis that the appeal was about a matter of statutory interpretation.
But so what should have happened? Because there wasn't any evidence, so the Court of Appeal was in as good a position to make a finding on this as would have been the trial judge.
That in my submission is true, just as your lordships would, but it was an appellate court, just as your lordships are.
So in a way, in my suggestion, we'd need to send this back is slightly beside the point, because you can't have a second chance to call evidence which you didn't call and chose not to call in the first court.
But my lord, the position is that they didn't inquire in detail into the evidence at all. They were concerned with the point of statutory construction. And their judgment is, and the ratio of the case as described by my learned friend in his objections, is that even if there was a breach, it wasn't something that was a breach within the Act, so there was no question of them being in default. Having come to that conclusion, there's no analysis of the evidence, there's no detailed looking at whether they were in breach or not, and the highest, Lord Justice Jackson put it, with whom the other Lord Justices simply agreed, in relation to the Occupiers Liability Act, was simply that no liability had yet been incurred. Now that does not decide any question. He could not see liability had been incurred. Well, it hadn't been incurred, but that does not decide the question of whether there was a breach.
Well, you say it's like the Hobbs case, the risk, or the other case you mentioned, the risk is enough, even if you haven't actually caused actual.
Yes, I'd say the risk is enough, but the point is there's a confusion of thought in my respectful submission between liability and breach. If I'm right in saying there can be a breach of obligations, whether they're under the Act or not, the factual question becomes, was there a breach of the obligations? And to say there was no liability doesn't answer that question, because liability could only arise under the Act if a person was injured or killed or property was damaged. So that wouldn't be the question to focus on. The question to focus on, which wasn't even looked at, was there a breach?
Oh dear, we're getting into the distinction between trespass and the action on the case, aren't we?
Well, my lady, what we're getting into in my submission is that there has been no determination in reality by the Court of Appeal of the factual issue. And all is said is, as a passing comment, that it couldn't be seen that liability had been incurred, which doesn't decide any question. And a court deciding matters of fact would say these are the factual findings, these are the reasons, this is what I rely on, and there's none of that. And the same with the Health and Safety at Work Act. They didn't look at the sections of the Act, they didn't look at the question of risk, there was no analysis of the evidence, and it is clearly the case that even if a person hasn't been convicted, that doesn't mean they're not in breach. And in my submission, it would be wrong to say that the first instance court, having not looked at all at the merits of the question of breach or any questions relating to the respondent's position on the Occupiers Liability Act or the Health and Safety at Work Act, that the court was trying to, in the Court of Appeal, itself substitute and make findings of fact, because that simply, in my submission, is not the reality. There is, however, shown to be a grave danger in sending this in any way to the arbitrator, because my learned friend presumably is going to try and repeat these points there and say, well, the court's found no breach of the Occupiers Liability Act and so on. But that would be a false basis. If the court is of the conclusion that the question is, was there a default? And the question arising out of that is, was there a breach of obligation under the common law or under statute, not limited to the Building Act? The correct course is for some court to decide whether factually there was a breach of obligations or not, based on evidence. And if that has to be the paper evidence, I'm quite content with that. But that has to be done, and in my submission it plainly wasn't done. And even in the context of the Health and Safety at Work Act, it was a passing comment. Lord Justice Jackson said, I cannot see that.
Yes, and one of the difficulties, of course, about the Health and Safety at Work Act, the obligation to the employees, is that even on the council's own view, the employees could still go into the premises.
Yes, but if the public were let in, they wouldn't be safe. So it stopped the public going in, so there'd also be a breach if they were wrongly letting the public in.
And the employees were there.
And the employees were there. And it's not just a duty to the employees, it's a duty to the state, where you can be prosecuted and convicted.
Yeah. But I mean, the issue for the arbitrator will not be whether they are liable to anyone else, but whether they could carry on their business lawfully, or indeed what their prospects of doing so, given they were given the state of the premises.
Well, I can only repeat my arguments that I shouldn't be at that stage.
In fact, as it happened, I don't want to go into the facts, that they were allowed, once they'd done certain repairs, the magistrates did allow them to carry on for a time, but this didn't seem to stop them going into liquidation sometime later.
Well, they were stopped for 3 months, they say, from doing anything. The court proceedings were taking place. We had no control over the timescale. Other people applied for adjournments, and it took 3 months. And they were then closed for 6 months until...
I presume, if you had decided in the first instance to go to the magistrates' court because you needed an urgent order, one might have expected the Magistrates' Court to sit up and take notice of that. But as it happened, the premises are being closed, and so the urgency had, to some extent, gone out of it.
Well, we didn't seek the adjournments in any way.
No, I'm not saying you did, but we can't really go into that.
No, well, quite. But they were closed for 3 months. We have all sorts of arguments, obviously, based on remoteness and what sort of losses can be recovered and all sorts if it gets the arbitrator. But Manolete's friend's point is that it can go to the arbitrators based on the fact that he says, factually, the Court of Appeal have determined that even if default means what I say, there wasn't a breach of the two acts, and it hasn't determined that. There's no finding of that.
For my part, I'd rather agree with you that
So it has to go back.
That issue, insofar as it affects the compensation, I can't see that the arbitrator would be bound by that. But anyway.
But it must, in my submission, at least go to the High Court to make that determination. If you find that I was legally right in my submissions before Mr. Justice Ramsey that breach of an obligation outside the Act would do, in which event, no doubt, he would have gone on to deal with the factual question of whether there was a breach of the Acts or not. Because if there was a breach of the Acts, then they're in default and it doesn't go to the arbitrator.
It's a question, it's a hypothetical, isn't it? The arbitrator you'll be entitled to argue before the arbitrator that if this had not, that during the period of closure, they would not have been able to do this, that, or the other lawfully. And that that may involve looking at, well, if the embargo had been put on them in other terms, might they have done that which was necessary to be able to trade profitably? One could see a string of possible hypotheticals. But there's why do those have to go back to the High Court rather than be matters for explanation in calculating compensation?
Because, well, this starts off with a Part 8 claim, and it's said that the respondents were entitled to a declaration that they were not in default and were entitled to compensation under Section 106.
Yeah.
The answer to that is given by the High Court. It doesn't matter because breach of obligations outside the Act doesn't affect the position. If the court had come to the conclusion breach of provisions in the Act does have an ability to give rise to a person being in default, it has to decide factually was this person in default or not before sending it off to the arbitrator. And it didn't decide was this person in default because it didn't think that question was relevant because breach of obligations outside the Act couldn't be a default. I'm very happy to deal with any more questions.
You have even more balls thrown at you. I think their stock is exhausted. So thank you very much indeed, Mr. Jastovitz. Thank you to everybody who has brought this fascinating little conundrum before us. We will think about it, discuss it, and let you know the result in the usual way. Court is now adjourned.